What are the limitations of a will? What's up, everybody? My name is Josh Key. I'm the managing attorney at Key Law. We take the headache out of estate planning and probate so you can focus on what's important. If you have questions about this or anything related to estate planning or probate and you'd like to speak to an attorney for free, you can do so by going to keylawllc.com. We have a schedule a session page. You can set up a time for us to talk. We'd love to see how we might be able to help you. So, what are the limitations of a will? Well, there's really two main basic limitations. First, a will does not avoid probate. What is probate? Probate is a court process that transfers your assets to someone else. And when you die without a will, they pull out this nice, neat little chart, and they run right down, and whatever the chart says, that's where the assets go. So you lose the control there, or probate basically looks at your will and says, hey, these assets need to go to this person, and it lets the world know, lets everyone know that that's where your assets will be going. And again, why do we want to avoid probate? Well, as I just talked about, it's very, very public, but it's also costly. Typically, you can have a flat fee for a percentage of the assets, and in some states, it can be extremely heavy. So, you know, if you take a $100,000 estate, in some states 3 to 5%, you know, you're paying a good little bit of money on that. The other thing is that the time. It can be months, even years, and at the bare minimum in the state of Alabama, if everything just goes perfect, it's a minimum of 6 months. So probate can be a very, very difficult process, and wills do not avoid probate as a revocable trust would. Second, there is no oversight over distributions. A will does not provide any oversight at all. So where does this come into play? So if you have a lump sum of money and you have kids and you give it to your mother or your father or to another family member to hold and to distribute out to help that child, basically when you do that in the will and you are trusting them to do that appropriately, you're really opening yourself up because there's no oversight. It's as if they get the money with no strings attached, and you're hoping that that person will keep to their word. But it opens up a whole nother can of worms. If that person's elderly and they have creditors or they pass away, it will go through their estate. It opens up a whole can of worms that that person's problems may have a way of end up affecting that. If they die and it says that they give all of that money or all of her assets or his assets to charity, that money for the child is gone and it will be distributed per their estate. So that's why a revocable trust is super important in that instance, because it can both provide oversight. It has someone who is looking at it that has been given a set of rules that they must follow to make sure that it is distributed per your wishes. And it also provides protection for the child, and it gives them an opportunity to make sure that they receive the funds as you wished in a way that is going to protect them long term. So again, if you have questions about this or anything related to estate planning or probate, you can speak to me for free by going to keylawllc.com. Again, my name is Josh Key. I'm the managing attorney at Key Law. We take the headache out of estate planning and probate so you can focus on what's important. See ya.